Welcome back. You're still watching The Globe. This week, the Constitutional Court held that a section of the legal practice is not unconstitutional to the extent that it precludes persons who are neither citizens or permanent residents in South Africa from being enrolled as legal practitioners. Now, in a case between Relebohile Rafoneke and Others versus the Minister of Justice and Correctional Services and Others, the Constitutional Court held that the reservation of the right to freedom of trade to citizens, as contained in Section 22 of the Constitution, doesn't infringe on the right to equality. But the question might be, if you enjoy the right to work and live in the country under another dispensation beyond citizenship and residency status, then is the concourt ruling fair? Well, I spoke to attorney Isaac Moselana, who told me that this case wasn't as simple as it seemed.
The Constitutional Court operates within the boundaries of the Constitution. And so if you're approaching the Constitutional Court, it is because you're saying that there is legislation that you're of the view it violates the Constitution in terms of Section 2 of that Constitution, which says that every act or law that exists, the Constitution is the supreme law of the country, that any other law which is invalid which is not inconsistent with the Constitution would be made invalid. Now, if you're approaching the Constitutional Court, you're saying to the Constitutional Court that there's a sections act or legislation that exists that we of the view is inconsistent with the constitutional laws of the country. We ask you, Constitutional Court, to uphold that. So we're not asking the Constitutional Court to invent a particular law and then put it in the Constitution, because if that was the case, then we would not have to do referendums for issues such as the land. We would simply just go to Parliament, which is allowed to amend the Constitution. So there was an approach to the Constitution based on an appeal from a High Court decision in Bloemfontein, not Pretoria, because the Pretoria one was withdrawn. Remember, in Pretoria and Bloemfontein, the court agreed that the people who don't have permanent residency or who are not citizens of South Africa can practice only, and be not practice, but only enrolled as non-practicing attorneys. The challenge and the appeal made by the applicants was that they don't want that. They want to be enrolled as practicing attorneys, and that the LPA, the section LPA, Section 224, violates that right in terms of equality, and also it was raised by other applicants in terms of Section 22 of the Constitution. So you are essentially going to the Constitution and say, look, Constitutional Court, and say, look at your own Constitution and tell us if this section in the Legal Practice Act is consistent with your Constitution. And the Constitutional Court says it is consistent. Their argument is it's not consistent in that it violates in terms of equality, in terms of the listed ground, in terms of Section 9.3. And if we look at the grounds in terms of Section 9.3, we realize that citizenship is not one of them. Then they said, well, social origin. But the definition of social origin is not yet fully explained in terms of our law. So you can't say that the word social origin is analogous to citizenship. Mm. And then they went on to further say that, okay, let's extend in terms of Section 22, which talks about the right to choose a trade, to choose a profession, which is only reserved to citizens. They say that that is inconsistent in terms of the Constitution. They said a section in the Constitution is inconsistent with the Constitution, which is a bit odd. And that definition should extend to foreign nationals in terms of Section 9. It would seem odd to use a section in the Constitution to make a section in the Constitution invalid. Seems odd in that line. But most importantly, or in addition to that, is that the Constitution have to uphold the Constitutional Court have to uphold the Constitution. The Constitutional Court cannot invent laws because a party feels perhaps the current laws in the Constitution are morally repugnant. We're told as South Africans that if that's the case, you go to the polls you vote, your party gets two-thirds majority, and they're able to change the constitution. And so for parties to then say to the Constitutional Court, read in and extend this definition to include so and so at the Constitutional Court seems a bit bizarre.
All right. So what you're saying is the Constitutional Court, all it does is it looks at the Constitution and interprets the Constitution based on the cases that it's brought before them and brings clarity so that people can understand. But there was at the lower courts a feeling by one of the courts that maybe this matter, the way that the Legal Practice Council, I think it's called, had acted was against the Constitution. And this is what needed clarity, that it wasn't right. So my question then becomes, for people like us who don't understand the law, help us understand when somebody has the right to work and live in South Africa under one of the permits, maybe as an asylum seeker or refugee, whatever, why would it be fair for them to be precluded to practice?
And that has been a question that has been mind-boggling for me. Then I had to look at the facts. If we go back to the decision in the Bloemfontein High Court or the Free State High Court, because that is the only decision which has been appealed. Yeah. It is also odd. It is also odd because you can't say that it is inconsistent with the Constitution, but they're only allowed to be enrolled as non-practicing legal practitioners. That is odd. But also you look at the position in which the court is put in place, is that the applicants did not come to court with clean hands. And this is my own opinion on this matter, because firstly, you cannot enter into articles of clerkship with a study permit. I agree, a study permit allows you to work, but on a limited time. You cannot be a permanent employee where you work 9 to 5 with a study permit. They argued that they use that. Some of the applicants don't even mention what gave them the privilege to work in South Africa without applying for a correct work permit. The other question is that, is being an article clerk on part of the critical skills? The answer is no, skills list. And so if you go through the applicants one by one, you realize that they did not come to court with clean hands, or maybe perhaps they did not know that when they were entering into articles, they needed to go through the Immigration Act. Mm-hmm. And this is what one of the arguments that the ministers are saying, is that they are approaching the Constitutional Court for the Constitutional Court to amend the LPA so they can circumvent the Immigration Act. Because in the first instance, the first question we should ask ourselves is, with whatever permit you have, if you have a ZEP, because let me deal with specifics, because I think the problem is if we take this matter in a general perspective, we may not be able to understand. Mm. One of the applicants is a ZEP. They are well aware that when you have a ZEP, you can work, because the ZEP initially as a political tool was used to circumvent the Immigration Act. You can work, but the question is, do you know that if you have a ZEP, you do not qualify for permanent residency? The question is, if the answer is yes, then you're well aware that then you'll be precluded to practice as a legal practitioner when you apply to do LLB, because you know that you need to have permanent residency or citizenship. So you know, but you choose ZEP instead. And then in future, when you don't qualify, you approach the court and say, but you allowed me to work with the ZEP. Why don't you just allow me to become a legal practitioner? And then, which is weird, because at ZEP, if it's not renewed, then what happens? You become a non-citizen practicing as a legal practitioner, already violating the LPA, for lack of a better word. Mm-hmm. It becomes a conundrum when we start going to the crux of the matter as to how did the applicants enter into articles of clerkship, work in South Africa without the correct work permits? Did they get a waiver? If you are using a general visa application, general work visa application, did your employer show the Labor Department that there is no South African that can do that job? Do you do that? So all these things were not actually dealt with by the Constitutional Court or even the High Court in Bloemfontein. Because if we had started there, this matter would not even go to court, because we would question the very hands that is coming to court. So we've dealt with ZEP, we've dealt with work visa. The other applicant had a spousal visa. Does that spousal visa mean that you would eventually apply for permanent residency or citizenship? And that is why once they realize that's the case, they won't be allowed to, then they're coming to the Constitutional Court to say, well, A, Constitutional Court say that Section 22 of the Constitution should also include foreign nationals, which is a bit weird, because you're simply asking the Constitutional Court to amend the Constitution in order to read in, which would be a bit odd, and which is surprising when I hear other people complain that the judgment is not good enough, and I question who has a right to amend the Constitution? At what level can we amend the Constitution? Why do we have to do referendums when we want to change Section 25, but people have said that the Constitution cannot be amended in the Constitutional Court? Which issues should be, and this is where I come in to say, in extension to this matter specifically, it's a bit infuriating that there are other social ills in South Africa that we are using the Constitution to say use the proper channels, but applicants wanted to go to court to ask the Constitutional Court to amend in order to suit their variable.
Okay, so I suppose in summary what you're saying is that it's important that all the different acts are read in totality so that one understands one's status even before you step into the Constitutional Court or go to a court in the first instance. Okay, all right. Well, thank you so much indeed for helping us understand some of this difficult laws for us lay people and giving us some clarity on that. Thank you so much indeed for your time, Attorney Isaac Moselana.
Thank you so much for having me. It's a pleasure.